it is undoubted that we should not have politicians with grave charges being in charge of the government. But it is also undoubted that in today's day and age, lots of cases are simply conjured out of nowhere, just like this kind of legislation being conjured.
Shouldn't this also be applicable to governors, MPs, MLAs? Why only ministers? Because they're all, public offices, and MPs are also elected by the people.
It's like in 30 days, get out of jail or get out of office.
Hello and welcome to another episode of InFocus. I'm G. Sampath. Mamata Banerjee has called it the death knell of democracy. And Rahul Gandhi has said it marks a return to a medieval age when the king could get rid of anyone he doesn't like. And Tamil Nadu Chief Minister Stalin has called it a black bill and said this is how dictatorships begin. The Constitution 130th Amendment Bill 2025 and two allied bills that extend its applicability to Union territories and Jammu and Kashmir were tabled by the government in Parliament yesterday. And clearly they have provoked massive outrage among the opposition. The bills essentially enable the removal of central and state ministers as well as the Prime Minister and Chief Minister who get arrested on serious criminal charges. And if the bills become law, any CM arrested on serious criminal charges will be out of office within 31 days of arrest. The government has justified these bills as necessary to bring in political morality in public office. The bills have now been referred to a joint committee of Parliament which will have to submit its report by the winter session of Parliament. So what is the rationale behind these bills? Are they anti-federal as some are alleging? And importantly, are they constitutional at all? And does the government have a realistic chance of passing these bills in Parliament? We discuss these questions in detail in this episode of InFocus. And joining us today is Sanjay Hegde, Supreme Court lawyer and constitutional expert. Sanjay, it's wonderful to have you here. Welcome to InFocus.
Thank you for having me.
So to start with, I was going to ask you, let's take the government's claim at face value, that these three bills have been brought in to sort of inculcate some sense of political morality and probity in public office. So what is the current status with regard to, say, a chief minister or a minister who is facing a serious criminal charge such as sexual assault or murder or whatever? What happens? Somebody is arrested for this kind of a charge. They can continue in office till the end of their term. Is that okay? Like what is the situation as of today?
See, a lot of things in the Constitution are worked by convention. And conventionally, if somebody is facing serious charges, they normally tend to resign. But these conventions have been slowly been eroded. You had the example of Jayalalitha, who got re-elected after she was convicted. And then she took oath. It was the Supreme Court which had to tell her that, no, you can't continue as a convicted a politician. So she had to step down. So that was the first instance of a breach. Now you had Arvind Kejriwal recently. He said it was a false case against him, and he may very well be right. But after he was arrested, he refused to step down. You had Senthil Balaji also, who despite being arrested was not removed from the cabinet, and then later on, once he got bail, the Supreme Court sort of ensured that he finally stepped down, so that the government is right in as much as it says that there is nothing there in black and white and therefore we are bringing it. But constitutional amendments are not like ordinary legislation. You don't need to prepare the mind or to prepare the polity for it. You can't suddenly pull out something from the back of your pocket and say, I've been thinking this all along. Now let's ram it through the house.
So usually when there is a new legislation brought in, there is some kind of a slipstream of discussion or debate which precedes it. There is some kind of a white paper or some committee has submitted some report on it. So this 130th Amendment Bill, Constitution 130th Amendment Bill 2025, this seems to have just dropped in out of nowhere. Or was there some kind of something preceding it which we think we missed and it has led to it? Like, what is your...
I doubt that there was anything that we missed because all the Kejriwal episode and Senthil Balaji is only late 2024 and 2025. But what this shows you is that lots of ideas have been worked on and some preparatory drafts are ready. You must remember that even when 370 was abolished, everything happened in a jiffy, which meant that the paperwork had been done well in advance. So, I do not know who are those, the deep thinkers who advise some deep state and then suddenly these things appear in parliament. It is undoubted that we should not have politicians with grave charges being in charge of the government, normally. But it is also undoubted that in today's day and age, lots of cases are simply conjured out of nowhere, just like this kind of legislation being conjured. If we are to draw a line, that line cannot be arbitrarily drawn immediately and out of the hat by a government. All stakeholders ought to have been consulted on this.
Right. So let's get to the actual provision of law, this amendment bill, and the two allied bills that extend its applicability to the Union territories and Jammu and Kashmir. So can you break it down? What do these bills actually do? So once somebody gets arrested, let us say by the ED on some charge of corruption or whatever. So if they are in jail, they have to be in jail for 30 days, and on the 31st day, they will either have to resign or the chief minister or prime minister or whoever will make them listen. Is that what the bill says? Can it?
The bill says that if the chief minister or the prime minister does not secure any resignation or does not advise the president to dismiss the minister concerned at the within a period of 30 days, on the 31st day, they shall cease to be ministers.
Okay. That is so far as ministers are concerned. What about chief minister and prime minister?
The same thing will apply to the chief minister or the prime minister. If there is no resignation, on the 31st day, they cease to be chief minister or prime minister.
What happened? They'll be forcibly dragged out of...
The person will be in jail and he will be told that on day 31, you are out. And somebody else will necessarily therefore have to take over.
Okay. So now, given that the justification is political morality and probity, shouldn't this also be applicable to governors, MPs, MLAs? Why only ministers? Because they're all, public offices, and MPs are also elected by people.
That, you see, they had to start somewhere. That would be the argument on the other. And MPs or even governors do not enjoy power directly. These ministers perform many executive functions. So executive power should not be in their hands. By the by, it is not as if this 30-day period ends up in a permanent disqualification. No sooner that you get bail, that you can automatically come back. Not automatically, you will have to be sworn in. So, if I were to make a bumper sticker out of it, it's like in 30 days, get out of jail or get out of office. That is exactly what this law provides.
So wasn't that exactly what the choice was that was given to Senthil Balaji? You referred to Senthil Balaji case. But he got bail and then he became minister again. And then the Supreme Court, correct me if I'm wrong, basically told him either you can be free, or you can be, if you want free, you can't be in office.
Yes, the Supreme Court expressed some very strong words, and Balaji resigned. So it has not come to a total declaration of law, as it were. But the Supreme Court nudged him to resign, saying that otherwise we'll have to cancel bail.
No, but so this whether this person is holding office or not, doesn't have a bearing on whether that person is guilty or not guilty, right? They're two different things.
These are two different things. Today, unfortunately, in India, you can be arrested and put behind bars without any burden on the investigators or the prosecutors to even prima facie prove guilt. You are arrested only because your presence is required to aid the investigation. And investigators can take their own time to come up to the stage of the charge sheet. You are technically a guest of the state. You are either in police custody or in judicial custody. And what does judicial custody mean? It doesn't mean that the judges have a nice little guest house where they've kept you. They've sent you to jail, but under their orders. So what is bail? Bail only says that, okay, uh, pending the conclusion of investigation or pending the conclusion of trial, please give me my freedom, and I am available to assist the investigation whenever you want, or I'm available to be there present at the trial, and I'm further available to bear the sentence if any is imposed. We never get to the stage in most cases of proof beyond reasonable doubt and a complete sentencing. So the entire criminal law is so bail dependent and bail driven. So you have an apprehension of being arrested, you run for anticipatory bail. If you don't get anticipatory bail and then you get arrested, then you have to ask for regular bail. Bail is granted normally depending on your record, depending on whether you are a flight risk or not, but the process takes some time. In most trial courts may take about a week, 2 weeks, or even more. But if the allegations are under specific legislations like the NDPS, the drug laws, or under the PMLA, they have some special clauses for bail. The judge can't give you bail because you're not not a flight risk and you're likely to be available, etc., etc. The judge has to be prima facie satisfied that you are not guilty of the offense. And he also has to be satisfied that you're unlikely to repeat the offense.
If the guilty or the guilt or otherwise of the person has to be established at the stage of the bill, then what is the rest of the criminal justice?
Exactly. And the Supreme Court in some judgments has really turned the cart before the horse, in as much as it said that you can't really come to a prima facie expression of innocence. You have to let the trial go. And in a country where trials go on for years and often trials are not focused, investigators tend to drag all and sundry into one charge sheet and the framing of charges, and trials in serious cases and drug cases and even the enforcement directorate cases can simply drag on for decades.
So in this law, Sanjay, it says that somebody, if they are in custody for 30 consecutive days, so basically a politician, a chief minister who's been elected by whatever, lakhs of citizens, and the government which has the backing of hundreds of thousands of citizens, that entire structure can be sort of brought to naught by some judge sitting somewhere on a bail hearing. One judge on a bail hearing can determine the future of a state, political future of a state. Essentially, isn't that what it means? Because a bail is going to determine whether you're going to continue as chief minister or prime minister or minister or not. If you get bail, you can continue. If you can't get bail, you will not continue. So, aren't you sort of perverting the entire structure of?
You are getting great power into the hands of the policeman who is investigating and who can decide whether to pick you up or not to pick you up and what charges to frame, what charges to levy. Thereafter, you're putting great power in the hands of the judge, as you were referring, whether to grant bail, whether to not grant bail, or whether to defer consideration of bail. See, there have been some illustrious journalists who got bail on day one after being picked up. But there have been ministers, especially of the Delhi government, who had to spend months and years in jail. And even on medical grounds, they were not let out. So, therefore, there is great discretion in the hands of the judge. And speaking for my own tribe, it gives great power to lawyers. It gives great power to defense lawyers who can get people out on bail. It also gives great powers to prosecutors who can just sit there and malevolently prosecute, or just simply extend it, saying that no, I have to be heard and I can't argue today. All kinds of things happen. So it's you have now set up a clock, and people have to run the gauntlet and run out that clock.
So would you say that you gave the example of Jayalalitha, who after conviction also wanted to continue in office. Would you say this law basically lowers the threshold for getting someone out of office just to that of being arrested? Would you be okay with it if, say, the threshold is conviction? A person should be able to continue in office until conviction, until the person is proven guilty. Would that be okay? Is that a fair threshold?
That is already the position, no?
Okay, that is
because if somebody is convicted and gets a sentence of 2 years or more, the person loses his seat, is disqualified from the assembly or the
set in place.
So that part is in place substantially.
Okay.
Now, before conviction, there are several stages.
Yeah.
There used to be a convention that if charges were framed by the court,
yeah,
and you had to plead either guilty or not guilty to them, it was at that stage that people resign, because anybody can file any case, anybody can make a complaint. It's only after after that complaint is filed, after there is investigation, a charge sheet is filed by the police, and then thereafter the court looks at all the evidence and then decides whether there is material to frame a charge or not. That is a stage at which maybe some action should follow.
Yeah, Hari, in 1999, the 178th Law Commission report said exactly the same thing, that chief ministers or ministers or whoever, if there is a situation where there is a framing of charges by a court, which is some kind of judicial application or the application of judicial mind has happened, then one could assume that there is some substance to these charges, and therefore the minister should be forced out by law or whatever. So would you agree with that, or do you think the existing conventions are enough and you don't need a separate law to enforce this kind of scenario where people have to quit forcibly, moved out of their position if there is a serious criminal offense in their name?
Well, unfortunately, constitutional conventions have not worked in India, or we are at a stage in our polity where conventions are ignored, they are stretched. So therefore, I think now we are safer in putting it down in black and white. The Law Commission may be right, but even at the stage of framing of the charge, there are many courts and there are many instances where there isn't that much great application of mind. But before the framing of the charge, the accused can always get up and say, "Sir, there is no material at all in the prosecution's case, so please discharge me at this stage." So to that extent, that is at least a discernible and a reasonable barrier to cross.
Okay, now let's come to the big fear that everybody has expressed, especially the upper position. When, as I said in my introduction, Mamata Banerjee has called it the death knell of democracy. There is a fear that it will be a law which would enable the regime in power to use arrest as a political weapon, to change basically the game, so to speak. So, what are your thoughts? I mean, you have written a column where you've said this could be used tactically before an election to sort of get someone arrested, from an opposition party, and thereby prevent them from campaigning, etc. Would you?
It's not only campaigning,
Yeah. Okay.
it's a kill switch for regime change. Let me just deconstruct the scenario. You spoke of Mamta, or there was Kejriwal, or there are strong regional leaders all over. They hold on to their flock the way most politicians hold on to their flock, various ways. Now, if they're suddenly towards the end of their terms, when they're looking at re-election, if they get arrested and they don't get bail for 30 days, within that period of 30 days, there will be so much uncertainty in their flock. Many people will be jumping ship. So, even if the person gets bail within that 30 days, say on day 25 or day 28, you may come back and see that all your flock has vanished. You may come back and see that you don't have the necessary wherewithal for the next elections. So, this is where any set of politicians are very vulnerable.
But if a chief minister is arrested, you could have someone else take over as chief minister, right?
Yes, they
And the party could.
yeah, theoretically yes, but Indian politics has seen Jitan Ram Manji in Bihar. You have seen Champai Soren in Jharkhand. You have seen OPS in Tamil Nadu. Whoever comes in however temporary a fashion, then tends to have a life of their own in that chair. And the dynamics change all the time.
But here
We are not necessarily a party run democracy. We are more individualistic in nature. The individual concern is the party. The individual concern attracts the party.
yeah, personality, culture.
Personalities matter.
Yeah. Okay, so but we are assuming here that the law might be sort of implemented in bad faith when there is not really substance in certain charges, they may just be framed, and a minister might be arrested just for a political vendetta or purpose. That is assumption. And is there any checks and balances built to prevent this kind of a misuse in this bill?
Not in the bill as it currently stands.
No checks and balances against abuse.
Nothing. It is mentioned a timeline and that's it.
Okay. Now, the other side of the question, Sanjay, is can this government pass this bill? It requires 2/3 majority. There is some confusion. 2/3 majority of the House or 2/3 of those who are present. If it is those who are present, then can that majority be manufactured through suspension of opposition MLA, MPs, and so on and so forth?
That can be. See, the first point is that it has to be a majority of the House. Now, the Lok Sabha is 543 seats.
Okay.
So, 272.
Okay.
272 is what you need to form a government.
Right.
Now, you have 272 members of your House, of your side, all present there and voting.
The NDA has 293.
Yes, but let's take the 272 figure.
Okay.
Yeah, they're all there present and voting. But on the opposition side, where supposing you said 290, so therefore they have what 230 something, 240 something. Now instead of that 240, you knock off about 50 people by suspensions or 100 people by suspensions. Then your 272 will be 2/3 of those remaining present and voting.
Okay, so technically it's possible.
So technically, I see it as a possibility.
And the same would have to then be done again in the Rajya Sabha as well.
Yes, it could be.
But if it is done fair and square, then the ruling regime would need 363 MPs out of 543 to be.
No. Again, that would be on the assumption that every opposition member also stands up and opposes the bill. You get legislation through various means. It is the crucial words are present and voting.
Right. So you don't even need to suspend anybody, right?
Yes.
To make sure that they don't show up.
That even if they show up, they don't vote. You may remember a famous instance where the impeachment motion against Justice V. Ramaswamy failed because the Congress was present in the House but did not vote. They abstained from the vote.
You had made some interesting points about democracy, you know. M.K. Stalin has said this is how dictatorships begin. You know, that's what the Tamil Nadu Chief Minister has tweeted on this legislation. And many have said, it's bad for democracy. And you made an interesting point where you have said that a scenario where legal institutions sort of step in and squelch or squash democratic impulses is what happens in Pakistan, Nawaz Sharif, Imran Khan. Can you please elaborate on that? Like, we have a very nationalistic government, but ironically, it seems to be taking Indian democracy in the direction of its sort of wanted adversary, which is Pakistan. So, how does this remind you of Pakistani democracy, so to speak?
No, this will enable the judges to be as powerful as some of the Pakistani judges who have played footsie with the army whenever the army wanted to get rid of an elected government. So previously, in Pakistan, the army would march in, but now they've decided that we should not necessarily march in and compromise our colors, but we can always run it. We can always have a politician of choice in office. So Nawaz Sharif got deposed through proceedings in the Supreme Court. There was some affidavit which the Supreme Court took exception to, and then he had to resign. Even this time, when his party is in power, it's not Nawaz Sharif who's in power, but his brother Shahbaz Sharif. Similarly, judicial proceedings were used to keep Imran Khan out of office. So I am afraid that if you A, give the judges this power, B, you retain the power with you to appoint those judges, there will be all kinds of coalitions of the willing and the unwilling, which can do a great deal of damage to electoral democracy. Disqualifying opponents from contesting elections is what dictators do. Erdogan did it in Turkey. He did it with the mayor of Istanbul, one Mr. Imamoglu or someone who was likely to be a candidate against him.
So does this also, in a sense, by eliminating the aspect of guilt from the equation entirely, it's only about arrest, not about guilt, does this also sort of cut out the judiciary from this entire military?
It doesn't cut out the judiciary. It makes the judiciary and the lawyers players in the game. On a different note, I was told once about a powerful Congress politician who had been chief minister of a state twice, who was seen saying yes sir, no sir to a particular person who was a judge. And so somebody asked him, look, when that man was a government lawyer, you never gave him the time of the day. Now you're bowing and scraping before him. What changed? He said, now he has the power to remove me from office.
So this is like this. Are we then seeing a situation where lawfare, so to speak, has become a big thing? Where the use of arrest as a political weapon, instead of being moderated or sanctioned or even normalized, so to speak, which is already becoming normalized, now it is getting sanctified. Would that be a fair assessment of?
Yes. So if we were to take that analogy further, lawfare now has an additional atom bomb, which can knock a chief minister out of the equation altogether.
An atom bomb which will tick for 30 days.
Which If it hits and knocks somebody out for 30 days, knocks the person out. Or which, when used, gives you a 30-day window in which you can change so many things.
Right. That's all I have for you, Sanjay. Thank you so much for
Thank you.
joining us. Thank you.